You've closed on the sale of your home and walked away with your sale proceeds, but you may end up hearing from the buyer after closing about loose ends of the transaction that need to be tied up. Today's tip will help sellers minimize the risk of being asked to take care of unexpected issues after the closing. Listen to the end to find out what extra step condominium sellers should be taking to limit their liability for upcoming assessments that have not yet been levied on the unit owners. Although for a buyer who's financing the purchase of property, there can be quite a bit of paperwork to sign at the closing, a seller might sign only these 5 common documents. 1, the warranty deed to transfer legal title of the real estate. 2, the bill of sale to convey the personal property such as appliances and window treatments. 3, a closing affidavit in which the seller swears that at the time of closing, among other things, there are no outstanding contracts to sell to another buyer, no boundary disputes with a neighbor, and no mortgages aside from the one being paid off at closing. 4, the disbursement instructions where the seller will sign off on how to receive their proceeds. And 5, the settlement statement, which for short is sometimes called the HUD, the ALTA, or the CD. The settlement statement shows the costs of closing to all parties and gets signed by the buyer, the seller, and the title company that is handling the disbursement of funds. Once the documents are signed by the parties, the deal is funded, and the parties go their separate ways. One loose end that can come up is an issue with the physical condition of the property. The 2 simple steps that a seller can take to minimize the risk of a buyer coming to them to express an issue with the physical condition of the property come well in advance of what they will sign at the closing table. The first is a detailed seller's disclosure of the history of the property, which is a readily available check-the-box kind of form. And the second is to insist on the use of the most recent as-is contract that's put out by the Florida Realtors and the Florida Bar, even if that's not the form that the buyer's offer comes in on. The as-is contract states that the buyer accepts the physical condition of the property by not exercising their right to cancel the contract prior to the end of the inspection period, and also contains a waiver of claims against the seller for damage or defects pertaining to the physical condition of the property that may exist at the time of closing and be subsequently discovered by the buyer. Of course, a seller still has a duty to disclose any facts materially affecting the value of the property that are not readily observable, but the use of the as-is contract can serve to cut off a seller's exposure for something that they didn't know about. Now for the extra step that condominium owners should take. Request copies of the association board's meeting minutes for the 12 months prior to the effective date of your contract. The agenda or the meeting minutes may disclose a special assessment that is pending but has not yet been levied on the unit owners. The board may not even have determined an amount to assess yet, but the boilerplate terms of the widely used condominium rider that gets incorporated into the parties' sale and purchase contract puts the burden on the seller to disclose both levied and pending special assessments, and any lack of disclosure results in the full assessment amount being the responsibility of the seller. If you're planning to sell your home, it's never too early to have a real estate attorney involved. Send a text to 561-225-2676 to set up a time to speak with me.